Hello everyone, I'm Debojit Das and this is Advocate Ostika Das. This week, courts have been asking some difficult questions about faith, about fairness, and about the limits of state power.
From the Supreme Court examining how far it can go in interpreting religious belief to high courts dealing with elections, criminal law, and executive accountability, we've broken it all down for you on today's episode of Courts This Week by LiveLaw.
Nowhere else to start, as the Sabarimala hearings were back before the 9-judge bench, but this time the court isn't directly deciding who can enter the temple. It's stepping into something which seems much harder, that is, who gets to question a religious practice in the first place, and what tools the court can use to examine it. Ostika, what exactly triggered this line of questioning on day 4?
It began with senior advocate Abhishek Manu Singhvi attempting to draw a boundary around PILs. He argued that courts should apply a very high threshold before entertaining petitions filed by non-believers, because otherwise PILs risk becoming a way to reinterpret religion itself. But the bench immediately tested that with Justice Joy Malo Bagchi posing a hypothetical. If a religious leader encourages mass suicide as a path to salvation, can the court refuse to act just because the petitioner is not part of that faith? Singhvi accepted that such extreme cases would justify intervention, but insisted those are exceptions. The ordinary rule, he said, must be judicial restraint. And the Chief Justice added another dimension, saying that in such extreme situations, the court may not even have to wait for a PIL and could act suo motu.
So the court is effectively asking if it draws that line, where exactly does it fall between belief and harm? But how did the arguments shift from that abstract question to Sabarimala itself?
That's where the focus moved to the character of the temple. Singhvi emphasized that Sabarimala is not just another temple, it worships Lord Ayyappa as a Nastik Brahmachari, an eternal celibate. And according to him, the restriction on women between 10 and 50 is tied to preserving that specific identity, supported by practices like the 41-day Vrat, and not a blanket exclusion based on gender. He framed this as a valid classification under Article 14, since women outside that age bracket are allowed entry. But the more controversial part of his argument was on constitutional morality. He warned that using it to test religious practices is both vague and dangerous, going so far as to describe it as a bull in a china shop when applied to Articles 25 and 26 of the Constitution. And notably, the central government has also questioned whether this doctrine should be used at all in matters of religion.
So if something like constitutional morality is pushed out of judicial discourse, then what standard is the court left with to test these practices?
That's where Day 5 added another layer. Senior advocate M.R. Venkatesh argued that practices around menstruation, like women voluntarily not entering temples, are matters of what he called discipline and belief, not discrimination. He said this is a long-standing, unwritten practice in many parts of South India, even within homes, and operates as a matter of faith. To support this, he relied on Dr. B.R. Ambedkar's Constituent Assembly speeches, arguing that the framers clearly distinguished between untouchability and temporary ritual impurity. According to him, conflating the two, as he suggested happened in the earlier Sabarimala judgment, distorts constitutional intent. He also questioned whether courts should even be defining terms like religious denomination, pointing out that these concepts come from Western constitutional traditions and may not fit India's religious diversity. And he warned that expanding judicial scrutiny, especially through the essential religious practices test, risks pulling core religious practices into state control.
So where does that balance land?
That's why senior advocate Rajiv Dhawan stepped in with a slightly different approach. He argued that what we often label as superstition cannot simply be excluded, because if religion is tested purely through scientific logic, very little of it would survive. He pointed out that courts are not meant to verify whether a belief is scientifically correct, only whether it is genuinely held. But he did acknowledge a limit. There has to be a threshold test to ensure that claims of belief are bona fide and not arbitrary or manufactured.
Next, we take a look at the recusal battle in the Delhi High Court, which is getting more layered. And not just because of what Arvind Kejriwal is alleging, but because of how the CBI and the judiciary are responding to it. At the center of it is a simple question. When does a reasonable apprehension of bias actually become something the court should act on? Ostika, what exactly was Arvind Kejriwal's case here?
So Kejriwal is seeking the recusal of Justice Swarnakanta Sharma from hearing the CBI's plea against his discharge in the excise policy case. His argument primarily rests on these 2 points. First, that the judge's children are empaneled as central government counsel, which according to him raises a reasonable apprehension of bias. And second, he's relying on precedent to point out that in Satinder Jain's case, a similar request by the ED to change the judge was accepted. So the argument is not just about perception, it's about consistency in how such requests are handled.
And how has the CBI responded to that? Because they seem to be pushing back quite strongly.
Very strongly. The CBI told the court that Justice Sharma's children have had no role whatsoever in the case and have never assisted in any proceedings. It also argued that children simply being empaneled as government counsel cannot be a ground for alleging bias. In fact, the agency went further, warning that if such arguments are accepted, it would open the door to litigants effectively choosing their benches by raising recusal pleas whenever they anticipate an unfavorable outcome. So the CBI is framing this less as a question of fairness and more as a question of preventing forum shopping.
But the concern Kejriwal is raising isn't about actual participation. It's about perception. Justice must not only be done, but also be seen to be done. So how is that being addressed?
For context, we can look at former Supreme Court Judge, Justice A.S. Oak, who's recently remarked that he would not have attended a program organized by the Akhil Bharatiya Adhivakta Parishad while serving as a sitting judge because of its perceived political inclination. So that's what you were talking about. Justice not only being done, but being seen to be done. Now, Kejriwal's plea also refers to Justice Sharma's attendance at such an event. So the issue is no longer just about family connections, it's also about whether associations, even indirect ones, can shape perceptions of neutrality in sensitive cases such as this one.
So on one side, you have the CBI saying this is an attempt to game the system. On the other hand, there's growing discomfort around how close is too close when it comes to a perception of bias. The next important story comes from the Supreme Court, as it has been looking at something that goes to the core of an election itself, not campaigning, not candidates, but who even gets to vote. This is the special intensive revision of electoral rolls in West Bengal, where, as per various reports, a very large number of names have been excluded. Ostika, what exactly has the court attempted to do here?
The court has stopped short of interfering with the entire exercise, but it has attempted to flag the consequences. It has said that persons whose names were deleted can still vote, but only if their appeals are allowed before the cutoff dates, April 21st or April 27th, depending on the polling phase. So in effect, the right to vote is now contingent on the speed of the appellate process. And that's where the critics have been pointing at. Because this isn't a small number. Around 27 lakh claims were rejected during the SIR exercise and a large number of appeals are still pending.
So the court is effectively saying you can vote, but only if your case is decided in time.
Seems like it. And one must note that this is also the first time that the court has expressed some skepticism, with Justice Joymallo Bagchi asking if the winning margin in a constituency is 2%, but 15% of that electorate couldn't vote because their names were excluded. What does that say about that result? That's not just hypothetical. It goes directly to the credibility of the electoral process.
And this isn't the first time the Election Commission has handled a revision like this. The court also compared it with Bihar, didn't it?
Yes, and that comparison is important here. Justice Bagchi pointed out that during the Bihar SIR hearings, the Election Commission had clearly stated that voters already on the 2002 rolls would not be required to submit any documents and asked them to refer to their own written submissions from that case. Here, however, for Bengal, the Commission froze the electoral rolls on April 9th, even though appeals against deletions were still pending. So the concern is that the Commission may have deviated from its own earlier practice without a clear explanation. And this is why the Supreme Court has now intervened in the manner that it has.
And what about the appellate process itself? Is there any indication of how reliable it's been so far?
There is, and it cuts both ways. In some cases, appellate tribunals have already found that names were deleted without proper application of mind. One example that came up earlier is Congress candidate Mohtab Sheikh, whose name was restored after the tribunal noted that the Election Commission could not even provide reasons for his deletion. So there's already some indication that errors may have occurred in the initial exercise. But at the same time, the Supreme Court had earlier refused interim inclusion of such appellants, meaning they remain excluded unless their appeals are actually decided within the cutoff dates that we discussed.
So you have a situation where the system acknowledges that some deletions may be flawed, but still requires people to clear that process before they can vote.
That's what it looks like. The court seems to be trying to balance two things that are just too difficult to balance. One, the need to stick to an election timeline with a clear cutoff, and two, the constitutional right to be on the electoral roll and to vote, which, as Justice Bagchi pointed out, is far more enduring than any single election cycle.
Staying with the Supreme Court, as it is now looking at a challenge to Muslim inheritance law. Ostika, what exactly is being challenged here, and why has the court been so cautious?
So the petition challenges provisions of the Muslim Personal Law Sharia Application Act 1937, arguing that they are discriminatory against women. Specifically, the issue is that under these provisions, women receive half or even less of what male heirs receive. When the matter was taken up earlier on 10th March, the bench flagged a potential structural issue. It said that if the court interferes with these provisions, it could create a legal vacuum because the Indian Succession Act does not automatically apply to Muslims. The court even observed that a uniform civil code could be one way to resolve this gap. So it asked the petitioners to come back with clearer suggestions on what should replace the existing framework if it is struck down.
So the court's concern isn't just about discrimination, but also about what fills the gap if the law is set aside. How did the petitioners respond to that?
Advocate Prashant Bhushan, who was appearing for the petitioners, addressed this directly by arguing that if the Sharia-based provisions are struck down, the Indian Succession Act can step in. But the Chief Justice immediately flagged the counter, saying this is personal law and someone will argue that it falls within that protected space. Bhushan's response was quite categorical, and he said personal law is not immune from constitutional scrutiny under Article 25, and if it is discriminatory, it must be struck down. He also pointed out how restrictive the current framework is. For instance, even in testamentary succession, a Muslim can only will away up to 1/3 of their property. So even self-acquired property cannot be freely distributed, which according to the petitioners further limits individual autonomy.
And what else did the petitioners place before the court?
The petitioners have also placed this challenge in a broader context by referring to other pending cases like Sufia PM versus Union of India, where an ex-Muslim is seeking to be governed by the Indian Succession Act, and Naushad KK versus Union of India, where even a practicing Muslim is asking for that option. So this is no longer a single challenge, it's part of a wider push questioning how personal law operates in matters of succession. There's also a federal dimension here. The petition points out that after the UCC in Uttarakhand in 2024, the Muslim community in that state may be governed differently compared to those in other parts of the country, raising concerns about unequal civil rights based purely on geography.
So the court is now being asked to step into a space where religion, property rights, and constitutional equality are all colliding.
And that's exactly why the court is moving carefully. It has now sought the union government's response, but the larger issue remains unresolved. Because somewhere the question is also whether the court can change it and whether it has the power to rewrite the entire framework of personal law itself.
Another interesting update from the Supreme Court as it looked at the issue of liquor being sold in tetra packs and the change in the court's approach. Austika, last year the bench had raised quite strong concerns about this, especially about danger to students. What changed this time?
It's hard to say. Earlier, a bench led by Chief Justice Suryakant had flagged that selling liquor in tetra packs could make it easier for students to carry alcohol into schools. But when the matter came up now, the court took a noticeably different approach. It disposed of the PIL, essentially declining to go into the issue and allowed the petitioner to raise concerns before the appropriate authority in Uttar Pradesh.
What reasoning did the court give for not engaging with it this time?
This time, the court focused on the absence of material. It noted that there was no policy document placed on record showing that the Uttar Pradesh excise policy explicitly permits sale of liquor in tetra packs. There was, however, an administrative decision dated 4th February that appeared to allow smaller packaging, but the actual policy framework wasn't before the court. And that gap became decisive here, it seems, and the bench said that without the relevant policy, it would not be appropriate to make any observations.
But the concern raised by the petitioner about alcohol being available too easily when it comes to children was still pressed this time, right?
Yes, quite directly. Counsel argued that such packaging normalizes alcohol consumption and makes it easier for children to access and carry it. At one point, it was even put to the court that children will start going to classrooms with tetra packs. But the Chief Justice pushed back on that line of reasoning this time. He said the form of packaging doesn't determine consumption, that those who want to buy alcohol will do so regardless. He also questioned whether there was any actual instance of such products entering educational institutions. So this time, the court held that it will not intervene without concrete material on record and has sent the petitioner back to the relevant administrative authority.
Next, a very important case in the Delhi High Court has now laid down principles on when POCSO cases can be quashed because the situation it was dealing with is not quite straightforward. We're talking about cases where the law treats a minor as a victim, but the person involved says there was no harm and in some cases is now married to the accused. Austika, how did the court approach this without diluting the law itself?
Justice Anu Jairam Bhambani draws a careful distinction. He says that the law recognizes the minor as a de jure victim, but the court must still examine whether there is an actual de facto victim before allowing prosecution to continue. And he quotes Oliver Wendell Holmes Jr. to make that point, essentially saying that the legal label alone cannot end the inquiry. But the court is very clear that quashing POCSO cases is not routine. It says such decisions require careful and sensitive consideration, especially when the victim says there was no injury or harm.
And what kind of safeguards has the court considered putting in place here?
Quite a few, actually. The court said it must be satisfied that the victim's consent or no objection is genuine, that it is given out of free will without pressure, coercion, or deception. It also warns that courts must remain alert to situations where offenders might use tactics, deceit, or emotional pressure to secure quashing. Beyond that, the court lays down factors to be considered. For example, whether the parties have been living together as a family for a significant period, whether children have been born whose future may be affected, whether there was any element of violence or brutality, and what the ages of both individuals were at the time of the incident.
So the court is also looking at the nature of the relationship.
That's right. And importantly, Justice Bhambani makes it clear that these principles are not exhaustive. Courts must interact with the parties directly and arrive at a subjective satisfaction that quashing is justified, not just legally, but on broader considerations of justice and to prevent misuse of the process of quashment. In this particular case, the court found that continuing the prosecution would be unjust and even detrimental to the prosecutrix and her child. So it quashed the FIR and all related proceedings. So the court is trying to hold two things together: protecting minors under a strict law while also recognizing situations where the legal framework may not reflect the lived reality.
On to a few other stories over the last week that happened that you definitely should take a look at. The Allahabad High Court has now ordered registration of an FIR against Rahul Gandhi, but this isn't about a recent speech or statement. This goes back to a long-running allegation about his citizenship. Ostika, what exactly has the court directed here?
The court has directed that an FIR be registered against Rahul Gandhi, who is currently the leader of opposition in the Lok Sabha, in connection with allegations relating to his alleged British citizenship. This stems from a complaint claiming that Gandhi had disclosed British nationality in documents filed with UK authorities, raising questions about his Indian citizenship. The High Court was dealing with a plea seeking action on this issue and has now directed the concerned authorities to proceed in accordance with law by registering an FIR. So this is not a finding on guilt, but it does trigger the start of a criminal investigation.
Another important case from the Delhi High Court that has now drawn a line on EWS reservation. If EWS candidates get reservation, do they also get the same relaxations as SC, ST and OBC candidates in other criteria too? Ostika, what did the court say here?
The court said no, it doesn't automatically mean that. The petitioners argued that while EWS candidates get 10% reservation under the 103rd Constitutional Amendment, they are denied age relaxation and extra attempts in exams like UPSC, unlike other reserved categories. They said this violates Article 14 and 16, but the court rejected that argument. It held that there is no basis to issue a writ directing the government to grant such relaxations, as it is strictly a function of the legislature, not the judiciary.
Next, a case about stray dogs at DRDO facility has now reached the Karnataka High Court, but the court's focus isn't really on relocation alone. It's on how the incident was handled and what evidence might still exist. Ostika, what has the court done here?
The Karnataka High Court has refused to lift the stay on the probe into the alleged relocation of community dogs from DRDO premises. So the investigation remains paused for now, but at the same time, the court has issued a crucial direction to authorities to preserve CCTV footage related to the incident. That's significant because it signals that the court wants to ensure that evidence is not lost while the legal questions around the probe are still being examined. This case itself involves allegations around how community dogs were removed from the premises illegally and whether due process and animal protection norms were followed.
Next, the Supreme Court has stepped in to stop a government decision, but this time it's not about policy, but it's about who is allowed to carry out a core public function. Ostika, what's happening in the Tughlaqabad Fort case?
The court has stopped the outsourcing of a survey of the Tughlaqabad Fort to a private agency, as it made a clear observation that the government departments cannot abdicate their statutory responsibilities by handing them over to private entities. This came up in the context of a proposed survey of the fort, which is the protected monument, where the task had been assigned outside the official framework. The court's concern was about accountability. When a function is entrusted to a public authority under law, that responsibility cannot simply be shifted elsewhere. So the court has now directed that the exercise must remain with the domain of the concerned government department.
And for our final story, the question that came up before the Madras High Court was pretty simple actually. What if a donation link looks like it supports government schemes, but the money lands somewhere else? What exactly is the citizen consenting to? Ostika, what's the allegation here?
So a Chennai-based petitioner has sought a probe into donations collected through the NaMo app and related platforms. He says that the way these links were presented and promoted through social media posts, including those attributed to senior leaders, created the impression that contributions would go towards government schemes like Swachh Bharat, Beti Bachao, Beti Padhao, and Kisan Seva. But after making the donations, the receipts he received were not from any government authority. They were issued by the BJP Central Office. That's where the petitioner says the misrepresentation lies. He then filed RTIs to check whether there is any legal framework allowing individuals or organizations to collect funds on behalf of such government schemes. And according to the plea, the replies were clear. There is no such provision. He also sought details on how the NaMo app operates in this context, and the response was similar. No such information available on record. The petition now seeks action against senior party leaders including JP Nadda and Amit Malviya.
Those were the biggest legal developments from the past week. But remember, for full reports and all the stories we talked about here and everything that unfolded inside courtrooms, head over to livelawin. Thank you for watching, and we'll see you next week.